Welcome, everybody, to the weird and, yes, wonderful world of body corporate strata management rights in Queensland. It's part of this regular series. My name's Chris Irons, and I'm director of a firm called StrataSolve, and that's stratasolve.com.au. Alongside is Frank Higginson, partner at Hines Legal, based here in Brisbane, and leading provider of strata legal and management rights services in Queensland. Frank, hello.
Hello, Chris, and hello, everyone, for what is our 100th webinar.
Far out. Far out.
Who would have thought at the start of COVID we'd still be doing these things 3 years later?
100. That's a substantial amount of content, isn't it? So what's that? That's
50 hours.
Yeah.
More than 2 days worth of solid play.
So what you're saying, I'm hearing, is that people should get a binge in. Pizzas, booze, chips, the works.
And yeah, we're going to take the staircase on Netflix next.
I think they've moved on to Dharma. But
some parallels with the strata world.
Yeah, look, possibly. Let's move on from that. But yeah, 100. I think that's worthy of a point of celebration. Thanks, everyone, for making it continuing worthwhile.
Putting up with us. Yes.
Yeah, absolutely. Before we get into the 100th proper, the usual bit of housekeeping. If you're listening in on YouTube, you can post your questions live, and we will get to as many of those as we can today. Welcome your comments, as always. But if you're consuming this, say, while you're out walking the dog, or as doing the dishes, or, driving in between meetings, as I know one of our regulars is probably doing as we speak, you can find all the notes and links we refer to at www.hineslegal.com.au. We're going a bit back to basics this week, aren't we, Frank, to a certain extent?
Yep. Still skittering around, and it just shows that despite having done 100 hours worth of content, we're still talking about some basic stuff that we haven't done. So it shows how broad this market is. I suppose the information void is the other way to put it. So, and I think this is probably a little bit for both of us in my mind, in terms of we get a lot of management rights questions, bucket loads of them. And some of those I think are probably predicated on people not necessarily understanding the basics. So this isn't, so today's webinar, we're going to rattle through a whole bunch of the things that you might or might not know, and hopefully everyone will get at least something out of it. But if you are being exposed to management rights for the first time, if you're new to strata or a new body corporate manager, or even if you're a manager and you bought your management rights, you're not going to know all of the things we're probably talking about today. So bit of whistle stopping, I think, Chris, would be the way to do it. It's not going to be 10 minutes on each topic. There'll be a couple of minutes on each topic, and away we go.
Yeah, it kind of more FAQs, aren't they, that we're going through today about management rights. I think we begin from the same place that we often begin these things, which is that in the same way that every building in Queensland is different, built differently, composed differently, so too we would say management rights arrangements are for each instance that they exist. The caretaker on one building, Frank, is far from the same as the one on the next.
Yep, and there is no standard agreement. That's probably the first rule of this fight club, in the sense of there's thousands of management rights agreements out there. Each one, and you'll see some firms more than others. We're probably one of them, but each one is different. Each one can be varied and changed over time. So it's not like you read one, you know them all. If you're actually looking into the detail of what the particular right or an obligation might be under any agreement, it starts with reading the thing. You can't assume anything.
All right. Let's rip into it then. Let's kick off with the first one, Frank. Is the management rights holder an employee or a contractor?
They're a contractor. So they are providing services to the body corporate in the same way that, Chris, you or I would, engaged for a particular purpose, for a particular service, for a particular fee. And to be honest, I think probably Seinfeld's got a lot to answer for in terms of some of these misconceptions. The doorman, I'll be gender specific, that was always there in the Seinfeld, the concierge, where the people walk in and they're there greeting them, all that sort of stuff. That's not what management rights is. So managers are contractors, which by its name, the management rights agreement is a contract. And what they're required to do is what's set out in that contract. No more, no less, as much as people will do sometimes less and absolutely will do more. But contractually, that's what it is. So they're not employees, the same as I can say to a staff member who's an employee of ours, I need you to be logging on at 8:30, finishing at 5 o'clock, and you can have lunch from 12 to 1. That's what an employee-employer relationship allows someone to do. Contractors aren't the same. Contractors will say, you got to mow the lawn once a week. When it's done is up to the contractor themselves. The same as if we get engaged to provide advice on a particular topic, we're not going to do it from 11:30 to 1:30 on a Monday. We're going to deliver it by Friday next week, and how and when that's managed is up to me internally.
It's well put, Frank. I like that. Yeah, I think remember the technical term for a management rights holder under Strata legislation is a caretaking services contractor, or caretaking service contractor. Remember, your answer is in the phrase, isn't it? Contractor. So it's not employee, it's contractor. So therefore, it's a contractual relationships. And as you say, Frank, the relationship between the contractor and the contractee, is that actually a word? Contractee?
Oh, you'd almost call them principal and contractor.
All right, yeah. So the relationship between a principal and a contractor is absolutely, as you say, not the same as a relationship between employer and employee. There's a lot of differences. That's a fundamental that I think gets missed a lot in the process.
Yep.
Let's try the next one then. Can the committee direct management rights holder to do things?
Depends. It's a wonderful legal answer. And it depends on the contract. So what does the contract say? So, and there's usually in these things, probably a standard type provision that you do see is that the manager will act as directed by the committee with respect to the duties into the agreement in certain respects. And that might be, and probably the easiest example is quoting. So, and again, this all depends on the words of the clause itself, but it might be quoting where committee says, oh, the pool pump's busted, go get a quote from Irons Pool Services and Higginson Pool Services for us, can you? And that then means the manager should go out and get quotes from those two people and not necessarily go to Pool Works around the corner because the committee's provided that particular direction. So I don't think that extends to, again, lawn services and whatever it might be. It usually is that quoting, arranging and supervising contractors. We want to knock over all the palm fronds. Can you go and get quotes from someone to get up there with a extendable ladder or whatever it might be and do those? It's that sort of stuff. So it's not to the same level as what you get in employment relationships, but there can be, subject to what the contract is, the ability to provide direction. And I suppose, Chris, where we get a lot of our work from, unfortunately, is when, again, that misconception about, a manager might be instructed to do something that's not part of their agreement. And so we've suddenly got the, what does the agreement say conversation.
And I think also all of that is right. And then I think if you look at this from a communications word point of view, Frank, direct. Direct has a particular meaning, doesn't it? It's a one-way street, effectively. Yes. That's the inference out of direction. Putting on my old public servant hat, you are directed. If you're given a direction, you do it. I'm not sure that this is what we're talking about here. And in any event, if you were to look at the situation, if I'm being directed to do something, it's quite possible I'm not going to take that too well. Whereas if there is a discussion or request or, whatever you want to call it, those are probably far more preferable things to say and do other than direct, I would have thought.
Yep. Get people on the bus. And dead set, one of the issues we absolutely have from a management rights perspective is managers not, and this particularly happens when you get a change of committee. So a previous committee might have been hands off, let the manager run the show. A new committee comes in, wants to be hands on and get involved. The managers can sometimes push back and say, no, I've always done it this way or whatever it might be. But ultimately, the manager is contracted to the body corporate and takes instructions from the body corporate in a number of respects, the same as we do as lawyers. I might say to a client, I don't think you should do that. You should approach it this way. No, Frank, I want to go this way. Okay.
Okay.
And
fair
away
enough.
you go.
Away you go. What's the tax situation here, Frank?
the remuneration. So I suppose the manager earns what they get paid from two sources. One is the letting side of things, which is by separate letting agreements with their individual clients as a real estate agent for people who they act for lots of, or act for the management of their properties. The other one is the remuneration they're paid by the body corporate, and that's a gross amount. So you might get paid 50 grand a year. It'll be plus GST because you're a contractor, the same as we charge, $100 plus GST. And then
when are you charging $100 plus GST?
Not much these days, mate, I can tell you. Thought, do I do 10,000? No, I'll do 100. Sounds less frightening.
No, fair.
Yeah. And then out of that, the manager needs to deal with their own tax, superannuation, whatever it might be. So there's no super in that. Again, the same as when we pay staff, we take off. We pay their superannuation separately, their superannuation provider. We take off their tax and we send that to the ATO with our BAS every month or quarter or whatever it might be. But from a management rights perspective, it all goes in gross. And then the manager can do what they want with that. Well, not can do. They've got to deal with it and with whatever their tax arrangements are from there. So it's a gross amount plus GST.
Okay. Next, and I can say this is one that I get asked a fair bit. I'm assuming you do too, Frank. And I'm actually getting asked it a fair bit lately as well. Does the management rights holder enforce bylaws?
This is the most, very common issue. And even the Commissioner's Office recently put out a common ground that dealt with this question specifically. So, and part of it is that management rights agreements sometimes have sort of nebulous wording about bylaw enforcement in there. So the old school clause might say something like the manager will police the observance of the bylaws. Now, whatever that actually means. The new school clause is going to say monitor the observance of the bylaws and report breaches to the committee. So, but in terms of enforcement, no, the manager doesn't enforce. The only person or the only entity that can enforce bylaws from a legislative perspective is the body corporate committee itself, or owners if they go outside. There's a process, and I suppose we'll go back to the flowchart. We did a webinar on bylaw enforcement a while back that referred to the flowchart that's on the Commissioner's Office website. Owners have the ability to get there if the committee doesn't do what they should be doing, but it's certainly not the resident manager's role to go around and physically enforce bylaws, as much as good managers will be knocking on your door or saying good day to you by the pool and say, mate, you know what? That's whatever that might be, you're parking at the car park. You just shouldn't be doing that. Perhaps there's a different way to approach it.
Absolutely. I think that's it. I think it's interesting to think about where that philosophy comes from, that the management rights holder does play that role. I guess it comes from the idea that they have this contract, this arrangement with the body corporate, and so that's an all-inclusive set of services. Everything which happens in the body corporate must be dealt with by this person or by this entity because they're being paid money by the body corporate. So therefore follows that they'll also be enforcing bylaws as well.
Yep.
I get it. I get why that feeling is there. And as you say, Frank, the management rights holder plays a huge part in getting the bylaws enforced through a variety of means, especially the ways in which you just spoke. But when it comes down to the mechanics and bylaw enforcement in Queensland, like it or not, the system that we've got is incredibly mechanical, incredibly prescriptive. You either do it or you don't, basically. There's no part doing it. That process is not for the management rights holder to do. One thing that we probably should note there, if that management rights holder also holds letting rights and is letting out their lot, and there's an issue involving their tenant in relation to the bylaws, that adds a different, what would you call it, flavour.
Yeah, absolutely. Because whether they do something with respect to the tenant depends on the instructions of their landlord, not the body corporate. So that's again, these relationships and the different hats that people can wear in these legal structures can be confusing, and that is absolutely one. So, it's not, in a sense, unreasonable for committees to look at a resident manager and say, it's your bloody tenant, go do something about it. Whereas the manager, as caretaking service contractor, doesn't have any special rights any more than any other owner to do something about it. But as a letting agent, they might have the ability to do it, but only if the landlord says to do something about it. And if
And
the landlord says don't, or I don't want you to do it, or that's my son in the unit and therefore don't go near him, that's what the manager has to do as letting agent.
I guess, Frank, that's more of an issue about understanding which hat you're wearing at which time as well. That kind of thing happens in the body corporate all the time, where you've got different occasions where you're wearing different hats, and you've got to try and figure out which one you're wearing at a given time.
Yep.
Next, does the management rights holder, Frank, have to live on site?
There used to be. So this is interesting. So again, as a contractor, we're back to what the contract says. If the contract says you must live on site, then you must live on site. If it doesn't, then you don't have to. So, and then obviously functionally, if it says you've got to have the pool open at 7 a.m. and shut it at 6 every day, you're either driving from wherever you live to do that, or you live in on site and doing it, which is a hell of a lot more convenient. There used to be a requirement under the previous letting legislation. So that was the Property Agents and Motor Dealers Act that disappeared in 2014. That removed, as a condition of a resident letting agent's license, the obligation to reside on site. So now the obligation to reside on site is purely a matter of contract, and probably good practice.
I think so, and I remember those days well, because I actually used to work in the real estate licensing section in those days, and I remember very vividly how potential management rights holders were scrambling to get their license that you just talked about there, Frank, and at the same time they were trying to wrangle the living arrangements. Usually, on the one hand, they were settling, trying to get the license, they were trying to settle the sale. And then they actually had to satisfy that they were living there, and there were all these bizarre rules.
Contiguous.
Contiguous. That's the one. Yes, about how close you were and how close you were. And I guess government got to the point where it said, "Hang on, we can't actually force people where to live," even though there'd be a lot of people listening to this who would say, "But hang on, they should be living here. They've got an integral role. You keep saying they have an integral role to play. They have to be living here." Get that? Totally get it. I don't think it follows that the only way you can optimally carry out that role is to live there. To me, it's about quality anyway, not how many hours.
You're just probably more, it's people are more comfortable if people are living there, as much as, you have the question, what happens if there's an emergency? Well, you ring the emergency services, you ring the coppers, you ring the fireys, you ring the ambos, and anyone can do that. It's not me doing it. If I was the manager. But yeah, it's still, it is one of the hallmarks of what used to happen. It's sort of happening less these days, the price of real estate and all that sort of stuff. But I still think, personally, the power of the management rights model comes from people living on site. I really do, because I think you build better relationships, and I think you provide a better service potentially if you're there. But,
Yeah, look, if it works, if it can work, it can work. But geez, that can be actually practically very difficult to achieve, I would have thought.
And I suppose it does come back to the person involved, doesn't it?
Yep, absolutely. Here's a good one, Frank. How long do management rights agreements go for?
Well, isn't this a topic of conversation at the moment? Community titles
legislation. I don't know what you're talking about.
Yeah, law reform working group. 2 modules, really. Standard and accommodation are where most management rights agreements are found. Standard module caps the term at 10 years. Accommodation module caps the term at 25. So that's the maximum term that an agreement can go for. Just because you're in that module doesn't mean that you have to have that. So you can have agreements governed by the accommodation module that go for 15 years, for example. Because once they're in place, they only then can be varied. And I suppose, Chris, jump into what the next question is. So you've got an agreement. How do you change it? Yep. So once you've got an agreement, it can only ever be, all agreements only ever entered into or varied in relation to term by general meeting, ordinary resolution, and a secret ballot. Variations other than in relation to term don't need secret ballots. So what tends to happen is agreements run down over time, or as everything does, we all get older. So a 10-year agreement that has 3 years into it, it's only got 7 years to run. So it's quite common and normal practice for the manager to ask the body corporate to increase that agreement back to 10 years. You do that usually at an AGM. And I think probably one of the You talk about misconceptions. The on-site residence one, we still get questions about that a lot. The other one is that agreements can be for longer than they were first granted.
Yes.
And by that, I mean, you might have a 15-year agreement in the accommodation module. You could take that out to 25 if the body corporate approves it at general meeting. There's this massive misconception. You can't go further out than what the original term was. And then that term is usually going to be broken down into, might be a straight 10 years, or it might be a 5 + 5. So a 5-year term with a 5-year option that requires exercising, that might have conditions on it and all that sort of stuff. So, and again, I suppose this is back to what we started with. Every agreement is different.
Sure is. And then is different. It is. The next logical question then, Frank, is selling management rights. What happens there?
Well, the body corporate, I suppose, for want of a better phrase, is an innocent third party in relation to a sale. So what happens is that, but the body corporate is a party to the agreement. So as much as I don't like comparing them to leases, because there's still, again, you look at motel leases, that sort of stuff, people have that in their minds. If you compare it to a shop in a Westfield, so if someone wants to sell a business in there, they need to go to Westfield and say, hey, I'm selling my business. This is Chris Irons bloke that's buying it. He's really good at running it. Here's his financials. Here's his bona fides, blah, 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 blah. And excuse me. And Westfield says, yep, he's right to go. That same thing happens from a body corporate perspective. So when a management rights owner sells, they go to the body corporate committee in this whole process we run. And what we'll do is we'll put up some guides. If you're interested in a lot more information, we've got guides that we publish for people buying and selling management rights. We've also got a guide we publish for committees in relation to the consent to assignment of management rights. So if you want more information, have a look at those. But from a committee perspective, where it gets to is they can't unreasonably withhold consent. So you can't say no. It's not like a job interview where you've got 15 applicants and you pick the best one. There's one person that's been put forward, and the committee can only say no if there's good reasons to say no. Now, what's good reasons? Wide and varied. If a buyer comes in with a criminal conviction for trust account fraud, that's probably a good one. GBH would be a good one.
What if, Frank, what about they have never mowed a lawn in their life? They have no caretaking experience whatsoever.
Well, I think if we did that, we never would have had a man on the moon. I think I'm being gender specific there because I don't think a woman has made it up there yet. But same thing. So to me, the issue then is showing from the buyer's perspective, and it's up to the seller to prove to the body corporate that the buyer can do the job. So there's training courses out there. You can go get work experience and all that sort of stuff. There's other ways and means. So really for me, done properly, if a buyer was worried about what their bona fides were going to be, there's training courses. Arama puts one on that helps people understand it. There's all these sort of things you can watch and learn. So, and I'd say mowing the lawn's not that hard. And I know that's a very simple example, Chris. There's probably more complicated things, city buildings with big bits of infrastructure and that sort of stuff. It's not a matter of just effectively walking in straight off the street saying I can do this. It's as much as I say to management rights buyer clients, it's not a job interview. They're not going to pick the best of you, but there's still no reason not to put your best foot forward and explain how you're going to do what it is that you're required to do, because that should be the committee's main concern.
First impressions last.
Absolutely.
What about if I'm on the committee, Frank, and the management rights are being sold or proposed to be sold, and I think that we deserve a cut of that pie as the committee?
So specific statutory prohibition on that. There is a thing called a transfer fee. So if a management rights agreement gets transferred within 2 years of the person first buying it, there's a fee that is 3% or 2% in the first year of ownership and second year of ownership that must be paid to the body corporate unless there's genuine hardship that the seller's transferring because of. But other than that, it's purely a contractual entitlement. So it's not a question of can the body corporate squeeze something out of it. It's the question for the committee is this person capable of doing the job?
But hang on, no. Don't we own the rights?
No.
Sorry, I'm playing committees.
Absolutely.
Don't we own the rights? Isn't it ours? Why shouldn't the body corporate profit from that, Frank?
Because the legislation specifically prevents it from doing so. And I think probably you'd say that's almost a bigger public policy thing. Like there's a statement in there that a requirement, bodies corporates cannot conduct a business.
Mm-hmm.
So what we've got is these vehicles that are effectively collective ownership bodies for all of the owners. And from a legislative perspective, the government said, you know what, you're going to have a very, very tight, strict set of rules by which you're going to operate, which is our legislation. And one of those is not really engaging in anything that could be considered commercial enterprise.
Yeah.
So clipping tickets and selling management rights and all that sort of stuff won't be done. And you can, so before people say, but we rent, to a telephone tower on the roof, that's not operating a business, that's acting as landlord, charging rent to give away some of the space.
Okay. Gosh, we're sort of rapidly getting to the end. Do we have time, do you reckon, to talk about terminating, Frank?
Oh, we can do it quickly.
Absolutely. All right, let's talk about it. So can you actually terminate the management rights agreement, Frank?
There is a legislative process to do so. So again, and this is one of the things that pops up quite often, and you do see the naysayers, for want of a better phrase, saying management rights agreements never get terminated and body corporates lose all the cases. And so firstly, the body corporates don't lose all the cases that get run. I would say that they lose a lot of cases where you're trying to terminate because someone hasn't picked up a cigarette butt. And when you look at it from a legislative perspective, and even from a fairness perspective, we've got someone that has invested X dollars in a business and is running it versus a cigarette butt that hasn't been picked up. And I know that's going to be the lowest of the lowest examples. If we're balancing the equities, I'm not going to terminate this agreement because of that.
Yeah.
As much as, and this is the thing, what the body corporates lose, probably on balance more than not, is the contested terminations. What people don't see is the uncontested terminations, because that happens too.
Yep. Sure
so
does.
We've been involved with them on both sides, where managers do the wrong thing and agreements are terminated, and that's it. So, but they're not public. And this is the thing, there's no public record of any of these agreements. So even when we talk about a number of management rights in existence across the state, it's a bit of a wild stab. I mean, probably more educated stab now than anything else, but it's not going to be precise, because even from a licensing perspective, not every management rights agreement has a letting side of things with it. So even from a licensing side of things, it's not even RLAs, because people get full licenses and lots of managers have that. So yes, it is possible, but it's not without its difficulties. And mind you, nor should it be.
Yeah.
You know what I mean? It's a big business. It's a big industry. So in terms of
you just flick a switch.
Yeah, something to an end, it's important to make sure that it's done properly and justifiably.
So those processes are the remedial action notice or a specialist adjudicator. That one not very well known, but that is possible. You can also look at alternative dispute resolution, such as mediation, if not to resolve an issue, at least to minimise the breadth of the issues at play.
That still is something that people should be doing. And the problem that I think we see with mediation is lawyers all know the benefit of it, particularly when they're on committees and the rest of it. And the other difficulty is that, and I don't know whether it's expectation setting or otherwise, a lot of people don't think about mediation until they've been belted around the ears for 18 months by lawyers and fights and sleepless nights and all that sort of stuff, because until then, they're going to win.
Yep, that's right. Win.
Yep.
We've got a good case. We've got a few questions there, or questions and comments, Frank. Warren, thanks, Warren. Can the committee make you maintain improvement structures that were not there before the contract was drawn up without compensation?
That depends on the agreement. And I think probably the biggest example I might have on that is foyers changing. So foyers go from being one particular type of surface to another surface that requires a hell of a lot more maintenance. To me, that's then back to what the agreement actually deals with. And I mean, we've just helped a client where a body corporate's improved a common property by installing gyms and all that sort of stuff, where we varied the agreement to deal with specifically those duties, which of course then dealt with remuneration as well. But in terms of existing stuff, in terms of do I have to do this new thing, it'll depend on the agreement itself.
Very good. Jeanette, thank you. Something about snakes and swimming pools?
No, leave them to you. We don't need to learn how to get them out of swimming pools.
Lynn, thanks for tuning in. Did you say the body corporate cannot run a business? We did indeed say that. What about self-management? I'm not 100% sure what you might be referring to there, Lynn. Frank,
I'm probably going to say self-management. So a body corporate in two respects, I suppose, isn't obliged to engage a body corporate manager, although most will. So there's some self-management, particularly of smaller schemes where people run their own levies, agendas, minutes, EGMs, AGMs, all that sort of stuff. In terms of a management rights component, a body corporate can't buy management rights. What we tend to see if we're going to bring an agreement to an end is a body corporate will negotiate a payment to the manager in exchange for the manager surrendering their agreements. And then after that, what the body corporate does with the management of it is up to itself.
Yeah.
So it might go and engage a bunch of contractors, committee might get on the ground, whatever it might be, but body corporate's not going to be capable of granting an agreement to itself. And if it, and I suppose the old faithful is, what about conflicts of interest, and they grant agreements to people that are on the committee, then it's back to being a management rights structure.
That's right. And finally and quickly, Sam, thanks, Sam. If caretaker keeps getting their contracts extended to keep it 10 years, is this more a financial benefit to caretakers if they were planning to sell before the end of their 10 years?
Well, I mean, it's definitely what caretakers will try to do, is to keep them topped up. And what I'd say is that the longer the term you've got, the more saleable the asset is. That's just fact. So if you've got two buildings side by side that are all intents and purposes the same, and one's got a 3-year agreement, and one's got a 10-year agreement, which one's worth more?
Yeah, that's right. We've come to the end. Gosh, that went by quickly. As per every other 99 of these that we've said. You can find all of the notes, all the links that Frank mentioned today, and there are quite a lot of them, at hineslegal.com.au. You can find me at stratasolve.com.au, and Frank as well at hineslegal.com.au. But until next time, thanks very much, everybody. Frank?
Again, thank you, mate.